There are 294,000 religious congregations in the United States. Protestant, Catholic, and Jewish traditions share a commitment to social justice. They shelter the homeless, feed the hungry, and provide counseling, health care, and daycare to those in need. Working together with elected officials at local, state, and national levels, faith-based individuals are making an impact.
Hello. Welcome to Making an Impact. Within 25 years, within days of the 25th anniversary celebration of the Civil Rights Act of 1964, the Supreme Court handed down a blizzard of decisions that made it much harder for victims of discrimination to get into court, much harder for them to get redress, much harder to get their cases heard, and much harder to obtain an effective remedy once their case had gotten into court. Just what did the Supreme Court do in this blizzard of decisions? And how are churches and synagogues affected and involved? That's the topic of this segment of Making an Impact. Our guests are the Rabbi David Saperstein. David is a lawyer and a rabbi and directs the Religious Action Center of Reform Judaism, which is the social action arm of the 1.3 million Reform Jewish movement. Faith Evans is also our guest. Faith is the Associate for Church Empowerment with the Office for Church and Society of the United Church of Christ, and was a community organizer during much of the time that this 25-year history since the Supreme Court, or since the Civil Rights Act of 1964. We want to look together at this whole field, looking specifically at what the courts have said, how it affects people, and how churches and synagogues are involved. So David, let's turn first to you and ask you to help us understand just what did the Supreme Court do?
Let me just take one of the many cases that came down to exemplify why it is harder for victims of discrimination to get into court, to prove their case, and to win. It's called the Ward's Cove decision, which dealt with salmon canneries up in the Northwest, which systematically discriminated against Eskimos and Filipinos who worked there and gave promotions and higher paying jobs only to white male employees. Prior to this decision, the way that plaintiffs for discrimination redress would get into court was to go into court and show that there was discriminatory impact of the policies of the employer. After this decision, they can't just show that there's discriminatory impact, they have to show how each and every policy of the employer leads to that discrimination. And if they cannot do that, even if they show discrimination exists, they can't proceed any further in court.
So they can't just show that there are no Filipino or Eskimo employees that are hired in the management positions. They have to
Correct.
Go beyond that.
They have to show how each policy led to that result. And then it used to be, once they would prove that there was discriminatory impact, that it was a burden on the employer to show why this policy, which had a discriminatory impact, was a business necessity. The court did two things. First, it changed business necessity, a difficult standard for the employer to justify a discriminatory policy on, to just simple business justification, a much easier standard to justify the discriminatory impact. And secondly, it took the burden off of the employer and put it on the employee, the person who was the victim of discrimination, to prove why the employer didn't have a business justification. And finally, in this case, it also allowed, under the old system, for the employer, after showing that there was a business necessity, to have to respond to the plaintiff's justification that an alternative policy could have been used, which would not have resulted in the same discrimination. Under the court cases, that is now a much harder thing to prove, where any difference and the alternative policy from the one that the employer was using will get that alternative policy thrown out as an option.
Let's try to break it down in terms of what this means for people, because when you get into the legal lingo, I think sometimes we get a little bit lost. But what does this mean for people?
Well, basically, it
what
means
if I'm an employee
that
at the cannery?
An employee who's a victim of discrimination now finds it much harder to prove that why there was the discrimination, how that discrimination came about. And it's harder to get into court. Once they're in court, more of the burden is on them as opposed to on the employer who used to have to justify the discrimination. And finally, it is harder for them to win the case since the employer has an easier time in justifying why there was a business justification of the discriminatory policy. So it's harder to get into court, it is harder to prove the discrimination, and it is harder to win even after they prove the discrimination has happened.
What would be another example of ways in which the court has curbed civil rights protections?
Well, there were several other cases, some of which said that once a decision had been, once a consent decree between victims of discrimination and employer had been reached to rectify that situation.
What's a consent decree?
A consent decree is where people who are suing an employer and the employer get together without going through a whole lengthy, costly court decision and say, look, there is a problem of discrimination. This is how we're going to agree to solve it.
So, Faith, how do the consent decrees apply to communities around the country that have worked out voluntary agreements to desegregate or to open up employment?
I just want to separate two things. When he said consent agreement is that the parties have worked it out, and in fact they were addressing the problem that existed within that institution, that they worked out an agreement to do that and to provide the redress to the individuals who in fact had a claim in the first place. On the other hand, some of the decisions that the courts have made have in fact affected cities around the country which did take a look at their discriminatory practices within their own cities, sat down, labor and a number of groups that sat down, worked out agreements about how minorities would be advanced or women would be advanced within their own employ. And when they worked out these agreements voluntarily, had basically satisfied large numbers of groups, the court's decisions now affect those decisions and in fact make them illegal, all right, to in fact, if they in fact measure up that someone might be, as they say, harmed as a result of those kind of decisions.
Yeah, basically, anyone who was not a party to the consent decree now for an indefinite period of time, 10 years later, 15 years later, can say, I, as let's say a white male, who wasn't part of this consent decree, is being discriminated against, and I want to reopen the whole case again. And it could be opened again and again and again. And that's going to make employers very leery about solving problems without going to court, lest they find themselves the victim of a suit over and over and over again as a result of the same problem. So it not only does it make it harder for the victims to get into court, to prove the case and to win the case, but now, even after they've solved these problems, whether
still
in court or not court,
it's
still going to be hard to get effective remedies because it will constantly be re-challenged. And these are just a couple of the 7 or 8 cases that have limited the rights. It's harder to sue states now. It is harder if you are the victim of discrimination to sue after a certain period of time of a policy has gone by in which a policy has been in effect. It's the opposite of the consent decree case. The victim of discrimination has time limits placed on them now. The white employee has almost an indefinite period of time in consent
to challenge
decrees.
The consent decree.
And what we are seeing is a pattern in which the Supreme Court of the United States, which used to be the fundamental guarantor of our basic rights, now is taking a very activist posture in limiting the scope of congressional legislation in protecting the civil rights of Americans and undoing the fabric of civil rights protections that's been built for the last quarter century.
How do we get to this point? What happened that the courts have made this tremendous pullback from civil rights protection?
Well, I think that there's been a basic, over the last 10 years, since the Reagan administration's entry into the White House, I think that there's been a consistent pattern to change all of these decisions that have resulted since the 1964 Civil Rights Act. They have, in fact, systematically attempted to open up cases that in fact decisions had been that had been resolved. They had literally challenged the Voting Rights Act. They sabotaged the United States Civil Rights Commission. They attempted to
say more. What do you mean?
Basically what they did is change it around to in fact fit the needs of in fact beginning to expound the idea that in fact we were now at a level of being a colorblind society, and secondly that we were now using these decisions to discriminate against whites in the society, and that in fact they were for a basic colorblind society that didn't discriminate against anyone.
Well, let's look at that. Is this indeed a colorblind society? Haven't we arrived at this? We've had 25 years of the Civil Rights Act of '64 on the books. Have we arrived at a point where we are a colorblind society?
I know, and everyone else knows that's out here in this world who will be looking at this particular show, that it's clear that we are not a colorblind society. That in fact race is a factor in many of the decisions that are made within the society and within the society's institutions. And there's no way of getting around it. The real question is, what is the role of the government and the courts in terms of protecting individuals from being discriminated against? And is the responsibility of the federal government, from the leadership, from the White House, from the Supreme Court down, to in fact try to balance the problems as a result of race and sex in the society, or is it to advocate for a particular group in society and in fact claim that the majority is entitled to the benefits over the minorities, and that they do have some right to in fact protect their interests in their society?
And we know that despite the advances that have been made in the improvement of the situation of civil rights in the past 25 years under the laws that have been passed, this nation still has a long way to go. 1 out of every 2 black children grow up in poverty. The unemployment rate for black adults is twice that for the general populace. Black teenagers looking for jobs, 1 out of 2, 50%, are unable to find jobs. Blacks still are systematically subject to discrimination in the areas of employment, in education, and we are in danger of recycling this problem into a permanent problem that really makes a mockery of our pretensions of fairness. The purpose of these laws that Congress had hoped would be broadly interpreted by the courts was to shatter that cycle. And now that the court has narrowed the description, they have taken away from communities and employers and courts all across the country the major tool to achieve that shattering of the cycle of perpetuating racism in this nation.
We're going to come back in a few minutes after we take a break and take a look at the Civil Rights Act of 1964 and look at some of the other arguments that the administration and the courts have made in the actions they've taken, and also to look at what congregations can be doing. Thank you. We'll be right back.
I was going to take a job with that engineering firm in New York. I got a better offer. I'm building schools overseas with the Peace Corps. The pace is a little slower than New York, but here I'm getting grassroots experience I couldn't get anywhere else. The way I look at it, the world can wait 2 years for another 40-story smoked glass high-rise.
Peace Corps, the toughest job you'll ever love.
Welcome back. We're talking about the Supreme Court decisions in June of 1989 that seriously restricted civil rights protections, which have been guaranteed for 25 years to populations in this country, minority populations in this country. How does all this affect real people?
That seems to me to be the crux of the issue, that these aren't just abstract laws, but civil rights laws and affirmative action programs that have made the lives of hundreds of thousands of women and minorities better by giving qualified people a chance. And I look at the contrast. The three of us have worked together for years and know each other. I look at the contrast of the two of you. Faith in the early 1960s tried to get into jobs and corporations, was discriminated against, had no redress of grievances, no agencies to protect them, and it was precisely the impact of that experience that led him to devote his life to civil rights. In contrast, 15, 18 years later, when you first joined our community here at the United Church of Christ, it was an affirmative action program that was seeking qualified women that brought you into our community, and within a few years the impact you had led the community overwhelmingly to look to you for the leadership position and impact that you hold now. It seems to me that indicates the power of these programs and how it shapes people's lives for the better, and that's the great harm being done by these Supreme Court decisions. So many people out in those churches now will not have opportunities that before this they used to have.
But what about the argument that innocent bystanders are getting hurt? That when you have set-aside programs or when you have affirmative action in place, that there are usually white males who are therefore not hired for the job. How do we counter that?
Well, I mean, if you also, if you've had and looked at any of the corporations, we've always had some preferences in terms of all kinds of jobs, even the jobs that in fact the federal government had in fact advertised out there to hire people. Veterans get preferences for 10%. Various groups in the society at different times are given preferences. Second is, if you are in fact allow people to discriminate, the extreme harm that does people compared to another extra 10 points that one may struggle with because a race factor has been put into it in terms of trying to improve the quality, you understand what I mean, or the level of work that person might be given in the community is quite different than, in fact, just going out and discriminating and not allowing those persons entry in any way, in any kind of jobs. I mean, we had whole unions here in the country where we knew that the only way that you could get into that union was that you were, in fact, white, you were related to the family, you had some kind of relationship, family relationship, or friend or political support that got you into a job. And that was unacceptable to us, and it's been unacceptable in America in terms of the last 20 years.
It's vital to differentiate between policy decisions that have a negative impact on some people. You build a mass transit system to make transportation better around the city. There are people who are going to lose their homes to that system and be reimbursed from, but inconvenienced by it. That's an impact on them, a negative impact. It's not discrimination against a class of people. That's different than discriminating against a class of people. In the Labor Department, they monitor all the federal programs that contain affirmative action policies. And of the tens of thousands of affirmative action programs that involve government contracts of one kind or another, in the last 15 years, only 3 or 4 have ever been proved to contain reverse discrimination. That's an astoundingly small percentage. On the whole, these programs work. They work fairly. They work with minimal impact on people in a negative fashion, and just make the community and society an open, more compassionate and fairer society.
And that's the reason the religious community is involved in civil rights advocacy and is opposing these Supreme Court decisions and supporting legislation that would try to redress the situation?
I think so. I mean, what we all share in common with our different religious perspectives is that all of us believe that every human being, regardless of color or sex or creed, is a child of God, created in the image of God, and must be treated equally, and that God, giving to us the bounty that we have on this earth, believes that we have to share that which we have with those who are less fortunate, those targets of special concern of God, the widow, the orphan, the powerless, the needy. And therefore, we see these kinds of policies aimed at giving exactly those people, people victims of discrimination and deprivation, a fair chance in our society as being part of our religious mandate to shape a better world for everyone.
Well, the court has issued its rulings, so in sense, and it has turned back a lot of civil rights protection. So what is the next step? What can be done to overturn that?
I think that what's on the table for the next couple of years is a struggle that's going to be waged primarily for legislative changes that will address those kind of problems.
So if the law is more explicit in protecting people's rights, the court will have to interpret the law.
That the legislation will reiterate what the role of the federal government ought to be in trying to address discrimination in this society.
Exactly. It used to be, ironically, that the Supreme Court was the major protector of our fundamental rights. It now is withdrawn from that task. And therefore, it is the Congress that we look to fill in the gaps left by these Supreme Court decisions. And working together to shape better civil rights laws has always been the task of the churches and synagogues in America. We've been key partners in the alliance that achieved that in the past and needs to achieve it now.
What shape would that legislation take? There will be bills coming out within the next year.
That's right.
What would they look like?
Hopefully, over the matter of the end of 1989, beginning of 1990, there will be widespread legislation that will fill the gaps in every one of these Supreme Court decisions and bring us back to where we were before those court decisions, based on the assumption that where we were before was a civil rights scheme of legal remedies for discrimination that served this nation well. We want to go back to where we were before. The last time the Supreme Court did it, and Faith and I and you worked together for 4 years to rectify that with the civil rights discrimination, when the court said that a institution receiving federal funds could discriminate in other parts of that institution's life which wasn't receiving the funds. We said no institution that received federal funds should be allowed to discriminate. It took us 4 years to undo that Supreme Court decision. But I think momentum is on our side now, that the majority of Americans are disappointed in the Supreme Court decision. And we can undo that quickly this time. So when that legislation comes down, I really hope that the churches and synagogues will begin to form alliances in every local community to educate people about those problems and to assume a leadership role in building a coalition that will work with Congress in passing it.
You're both involved in a coalition that isn't addressing these issues through Impact. You want to say a little bit about how people can get timely information about civil rights legislation that is coming up and when those votes are taking place?
Well, most of us participate in Impact and working in its different groups, task force, and the Civil Religious Liberties Task Force in those groups in terms of trying to at least help the church access itself to the information here in the Hill. Second, that we each in our offices have networks of people that are involved more directly in addressing legislation. And my task in the Office for Church and Society is primarily to help the church understand where they can play a role, nationally and locally, in terms of communities and how people can be empowered to work with minorities and other churches to try to effect change in Congress when we need to have that kind of thing addressed.
And Impact uniquely allows all of the viewers to get involved. It allows people to join a network which is the preeminent network of social justice within the religious community, of people concerned about trying to shape public policy. And people can join and be part of this nationwide network of concerned religious people who want to use the political process to shape a better America. And I really hope that people will do that and thereby work in a partnership with us.
So congregations and individuals can write to National Impact, say they're interested in civil rights and this particular topic, and either get this show, but also get copies of publications that Impact puts out on these issues, catching people up on what's happening legislatively.
And each person can choose that sub-network of Impact which interests them most, and I hope that everyone's going to be interested in joining the Civil Rights Network that will link together people in a common concern to pass this legislation.
Part of the history of this country, I think, is a long struggle to try to maximize civil rights protections for people, and as you so eloquently said, to protect those who have been disenfranchised, have been persecuted, etc. We have a copy of the Civil Rights Act of 1964 with us, the original act, and I thought it'd be useful to just share a quote from Congressman Gus Hawkins, who was in the Congress as a freshman member 25 years ago when that debate on the Civil Rights Act of 1964 was taking place. Learning the ropes, he said, after a career in the California Assembly. He said, "I was involved in the House debate on the Civil Rights Act. As the first black representative elected from the West, I was keenly interested in the direction of this debate. I'll never forget the hours of hard discussion in committee and on the House floor and the parliamentary maneuvers used by opponents to bottle up that bill. But the Senate finagling was even worse. 75 days of filibuster and the introduction of 119 weakening amendments. And it was the shock of President Kennedy's assassination that provided the catalyst that finally pushed that bill to being passed." The struggle has been a long one and a painful one, and the religious community has been very involved for a long, long time. As we look forward to this next year, we're going to be needing the support of people from all different areas of the religious community to get involved to help legislate changes that will push back the decisions the court has made.
In interpreting this legislation, it has been precisely the Supreme Court, through a broad construction of that law, which has asserted the rights of women and of minorities, of blacks, Hispanics, Catholics, Jews, handicapped people, against the indifference and sometimes harm of the majority, that has created a more just and fair America. It would be a shame now to abandon a court that was committed to a vibrant and growing constitution that affirmed these rights.
You mentioned handicapped. You mentioned handicapped people. There's legislation now that the religious community has been working on. Do you want to say a little bit about that? The Americans with
Well, there's an excellent bill, the Americans Disability Act, that will give the same kind of civil rights coverage that we've given to minorities and religious groups and women to handicapped people too. It will make access to buildings much easier, equal employment opportunities much more thorough in this country. It's been carefully worked out in a compromise version involving the religious groups, the handicapped groups, the Congress leadership of the Republicans, Democrats, and the White House. But there are extremists who are trying to undo the bill, threatening to filibuster. And in order to have this bill succeed, we need to hear the voices of grassroots people all across the country. And since churches and synagogues are exempted under this law for historical reasons, we also need the churches and synagogues to take voluntary action to provide for the needs of their own handicapped members.
And Faith, what do you think the future is going to bring?
Well, I mean, I have to remind you that in 1964, when the Civil Rights Act was in fact signed, Malcolm X comment was about it, that in fact it was a carrot and a stick that was able to be taken away at any time. We are in a situation right now where it is extremely important for people to be aware of the fact that the court is going to be making more decisions in this arena, and that in fact a lot of people's lives are going to be in fact impacted by that.
On that, we'll have to close. Thank you very much, Faith Evans and David Saperstein, for being with us.
Thank you.
Sometimes I feel my dreams don't matter, that I am just too small.